Ready to start on your marriage adjustment journey after overstaying your tourist visa? If you're married to a US citizen and not sure how your tourist visa overstay will impact you, this video is for you. Here, I will answer the most commonly asked questions such as how to get a green card without leaving the US, what happens if you work without authorization, and how to properly disclose it. In addition to discussing waivers and whether you will need one, I will also share everything you need to know about 3 and 10-year bars to prevent you from making a costly mistake. And make sure to watch to the end where we will be discussing what questions normally come up during the interview in these types of cases. If you're new to our channel, I'm Margarita, and on this channel we share new videos weekly with practical tips and tricks to help ambitious immigrant couples successfully get their green card without wasting any time and without hiring a lawyer while doing it right and on the first try. The biggest question you might be asking if you're fairly new to this process is, can I get a green card inside the United States after overstaying my visa and marrying a US citizen, or do I need to leave the United States to apply for a marriage visa abroad? Look, marriage to a US citizen makes you eligible for adjustment of status even if you have overstayed your visa. Immigrants are often unaware of this fact and they erroneously assume that the only way they can get a green card is if they depart the US. Doing this is a very bad idea, and we will talk about a 3 and 10-year bar later in this video so you know exactly what that's about. Just know that you can get a green card inside the US even if you overstayed your visa, even if it's by a few years, so long as you entered the US with inspection and you meet all other eligibility requirements. The US citizen spouse can petition for you by filing Form I-130, but that's not the only form you will be filing, so make sure to download our free mini course linked in the description for the list of all the forms you will need. Just way too many forms to list here. Just so we're on the same page, let's look directly into the USCIS policy manual for the language they use. First, you need to know that there are certain factors that prevent you from getting your green card inside the US. For example, if you're not in lawful immigration status on the date you file the adjustment application. But as per USCIS policy manual, certain adjustment bars do not apply to immediate relative, including the spouse or child of a US citizen. Even if you fail to continuously maintain lawful status since entering into the United States or have ever violated the terms of your non-immigrant status, you will still be able to get your green card so long as you're in a bona fide marriage with a US citizen. Before we talk about unauthorized employment, it's a reminder that we designed a method where we provide easy-to-follow, step-by-step guidance that helps couples like you secure your green card and citizenship independently, all while reducing time waste, stress, and uncertainty. And I really feel like sharing this win from inside our community with you guys to celebrate yet another amazing human being who was able to get their green card with ease. Seeing posts like this is so encouraging when you go through your own process, and it obviously warms my heart that my negative immigration experience can transform into something this positive. You can schedule a strategy session with me using the links we've provided in the description and in the comments. All right, another question you might have is, but what if I worked without authorization during this time? Obviously, it's nearly impossible for somebody to live inside the US for years without being employed, and the USCIS understands that as well. Very often, immigrants are afraid that working without authorization could prevent them from getting their green card inside the US, so they often try to hide it, which can often lead to more issues. Again, inside the USCIS, they understand that you cannot possibly survive in the US without being employed, especially for prolonged periods of time. Let's again look at the policy manual for a second time. Similarly, with the visa overstay, an adjustment applicant applying as an immediate relative may be eligible to adjust status even if the applicant is now employed or has ever been employed in the US without authorization. We call it your unauthorized employment is forgiven, but that only applies to spouses of US citizens. It's a pretty broad statement, and you do need to understand that the use of fraudulent documents such as social security cards or green cards, and especially claiming to be a US citizen, has some serious consequences, and in these cases you should 100% speak to a qualified attorney. But if you got yourself an ITIN number or a tax ID, or if you had a social security number from your past internships or employment, and you were paying taxes on your income, then you don't have much to worry about. Another question we often get is, okay, I did get a tax number, I did pay taxes, but I don't feel comfortable disclosing this information to the USCIS. In this case, the choice is very obvious. There's no point in lying when your unauthorized employment is forgiven. Now, you're risking misrepresenting facts to the government agency, and if discovered, the consequences are harsh and you will ultimately need a waiver. Obviously, in situations like these, it's always a good idea to speak to an attorney, but every normal attorney will tell you to disclose that information. Another common belief immigrants have is that they will need a waiver in order to get a green card after overstaying their visa. And immigrants are often fearful about overstaying, so if you have fears around this, just know that you absolutely are not alone. When people handle these cases without lawyers, and sometimes even lawyers unknowingly do it, they sometimes submit the waiver together with the rest of their application, not knowing that it is absolutely the wrong thing to do, and it causes a lot of confusion for an immigration officer, so you do need to make sure you know what you're doing. If you aren't sure if you need a waiver or not, it means that you really don't understand this process well enough, and you do need to speak to somebody right away before proceeding any further. Again, don't hurt yourself and don't make this process longer and more complicated for yourself. So long as you haven't departed the US, meaning you entered with your visa, you overstayed it, and you're still presently in the US now applying for a marriage adjustment based on marriage to a US citizen, and you're fully eligible otherwise, you do not need a waiver. Another question we often get is, will I have a harder time getting my green card since I overstayed my visa and worked without authorization? Generally, the answer is no. Remember, marriage to a US citizen creates a valid pathway for adjustment of status, and USCIS primarily assesses the authenticity of your marital relationship and obviously the eligibility of the sponsoring spouse to petition for their spouse's green card. But don't get me wrong, it is essential to address any unlawful presence or unauthorized work issues appropriately on your application. You do need to answer those yes or no questions on Form I-485 correctly. For instance, when it asks, have you ever worked in the United States without authorization? Obviously, it's a yes if you had. Have you ever violated the terms and conditions of your non-immigrant status? That is also a yes if you overstayed your visa. And don't forget to provide an explanation for each yes at the end of the form as well. That is very important. If you are invited for an interview, the officer might give you a harder time and ask more questions about that, but we will cover that in just a minute. All right, now let's briefly discuss the 3 or 10-year bars. The 3-year and 10-year bars refer to periods of inadmissibility that individuals may face if they accrue unlawful presence in the country and then depart. For instance, if you accrue more than 180 days but less than 1 year of unlawful presence in the US and then you depart, you become subject to a 3-year bar. This means you are ineligible to re-enter the US for a period of 3 years from the date of departure. If you accrue 1 year or more of unlawful presence in the United States and then you depart, you face a 10-year bar, rendering you ineligible to re-enter the US for 10 years from the date of departure. Sounds super scary, and it should be, because you have no idea how many people don't properly research, or they just speak to some uninformed people, leave the US, and are then unable to enter. Remember, the main part here is accrue unlawful presence and then depart. So long as you don't depart and you're still in the US, you're good to go. If you depart, however, you will need to apply for a provisional unlawful presence waiver and work with an attorney on that process. All right, so finally, what happens at the interview, and will they ask about your visa overstay and unauthorized employment? Fair question to ask, so let's tackle it before you go, since it's of course a valid concern. First, you definitely heard about all these interviews being waived in 2023, and if you haven't or you're curious to learn more, check out our video here. So it's possible your interview might get waived, but it's no guarantee, since even with straightforward cases, we're still seeing them being scheduled for interviews. Thus, let us imagine that you are scheduled for an interview. The officer can and likely will ask questions about your immigration history, in addition to all the relationship questions they will ask as well. Either way, the officer will take you through those yes or no questions on Form I-485. And remember, you provide a lot of the information in your application. That is why it is so crucial to make a copy of your application prior to submission so you can review it before the interview. The only idea here is obviously to be honest. So long as everything else is good, your visa overstay will not prevent you from getting your green card, but you have to be honest about your answers. They can ask you when your B2 authorized stay expired and why you haven't departed the US prior to that date. Same with your unauthorized employment. So long as you disclosed everything on your application and you never claimed to be a US citizen, Your unauthorized employment by itself cannot prevent you from getting your green card. As far as questions go, they can ask questions like, where are you currently employed? How long have you been working there? They can specifically ask, have you ever worked without authorization in the United States? If you have worked without authorization, can you explain the circumstances, etc.? Remember, if you aren't sure about your specific situation or you feel like your case might be a bit more complicated, it is always a good idea to speak to an immigration attorney to get some proper guidance and on where you stand. Thank you for watching. Drop whatever questions you have in the comments and we will make sure to get back to each and every one of you, and I will see you next week.